Biotechnology has become a very important tool for many research and industries. Louis Pasteur, we know, was granted a French patent in 1865 for yeast clones that he isolated for mixtures of yeast species. The first successful cloning of a sheep named Dolly in 1997 advanced a genetic engineering of prominent fame globally. We know regarding Dolly, the creation of Dolly, there's an important achievement that made by the scientists in field of cloning. The application of technology to agriculture.
Studies in Law, Dean Faculty of Law, Bangalore University, to the valedictory function of this workshop on copyright and patent law for the layman. Dr. T.R. Subramanya hails from a small village of our own district, Dakshina Kannada. He has PhD in law from Jawaharlal Nehru International University, New Delhi. Prior to his present position of a Professor of Law, Department of Postgraduate Studies in Law, Bangalore University, he worked as legal advisor to the government of Bahrain for a period of 10 years. Dr. T.R. Subramanya has been visiting several national law schools and law schools of national repute as a visiting professor. He is a visiting professor in human rights law and intellectual property law at the V.M. Salgaonkar College of Law, Goa University. Visiting professor of international law at the Center for Latin American Studies, University of Goa. Visiting professor of international law at the Indian Academy of International Law, Indian Society of International Law, Bhagavan Das Road, New Delhi. Visiting professor, Kerala Law Academy, Tiruvananthapuram. Visiting professor of National Law School of India, University, Gujarat. Visiting professor, School of Indian Legal Thought, Mahatma Gandhi University, Kottayam. Dr. T.R. Subramanya has been on behalf of Kilpar and SDM Law College and Postgraduate Studies in Law and everyone present here, I heartily welcome G.T. Vijayalakshmi, Special Officer to Director, Kilpar, Bangalore, to this function. I request Dr. B.K. Ravindra, Principal and Director, to hand over a bouquet and memento to Madam. On behalf of Kilpar, Bangalore and everyone present here, I respectfully welcome our inspiration in all our endeavor, student of LLM, to honor Dr. B.K. Ravindra. On behalf of Kilpar and SDM Law College and Postgraduate Department in Law, I welcome the resource persons present here, delegates, invitees, my colleagues.
Ladies and gentlemen, Professor Ravindra, Principal of SDM Law College, Bangalore, Madam Vijayalakshmi, Officer in charge of Kilpar, distinguished teachers, members of the media and the press, ladies and gentlemen. From morning until now, you have been listening to the various areas of IPR. Having heard a lot of it, I was just thinking what to speak, because under no circumstances it should not be a repetition. If it is a repetition, it is a waste of time, and more than anything, it is a waste of energy. And you don't have the time to concentrate time as well. Now, when we take up the law of IPR, I just wanted to speak to you. A student of law cannot ignore the basic principles of international law. Since this audience is composed of most of the law students, I thought I can take the liberty of speaking of this. So you just take an instance relating to an agreement relating to IPR. When an international agreement relating to IPR that is being signed, what exactly the rules of international law that are to be followed? Now this must be respected by every student of law. Now when we take up this matter, look to the Charter of United Nations itself. And you might be knowing that there is a charter which is called as the United Nations Charter. Now the Charter is like the Constitution of India. Now the Charter has 110 articles. We are not going to discuss all the 110 articles, nor it is possible even to read. But then, Article 2 of the Charter of United Nations lays down the basic purposes of the Charter. When we speak about the basic purpose of the Charter, at least 3 principles stand prominent. And no scholar in international law or a scholar in the area of APR would be in a position to forget this. Now, the first principle that is being spoken, enshrined therein, is Article 2, Paragraph 2. Article 2, Paragraph 2 of the United Nations Charter makes it very clear. It is the duty of a particular state to carry out the obligations of a treaty to which it is a party under international law. Suppose, for example, state A, here you have at least 50 students. 50 states have signed a particular treaty. And when 50 states have signed a treaty, maybe a TRIPS agreement, or maybe relating to the WTO agreement proper, it is the duty of each member state to carry out the obligations of the treaty faithfully to which it is a party. And there cannot be any escape from this principle. That is the fundamental role. So when once you become a party to WTO, when once you become a party to TRIPS, when once you become a party to the other agreements relating to IPR, there is no question of going back. You are supposed to answer it and carry it out faithfully. That is the answer. Now the second principle that is being spoken is, all international disputes or bilateral disputes by member states of the United Nations are to be settled peacefully. It is Article 2, Paragraph 3. If you are a member nation of the United Nations, it is your duty to settle the disputes to which you are a party peacefully. You cannot aggravate the problem. You cannot take it anywhere else. There is no such thing as, remember, violating the international peace and security. The moment you violate international peace and security, even in trade matters, the Security Council will come into the picture. So all bilateral agreements relating to trade, relating to commerce must be settled by states peacefully. This is another caveat that is being pointed out under international law, especially under Article 2, Paragraph 3. Now if you look to Article 2, Paragraph 4 of the Charter of United Nations, it points out, no state is supposed to violate the territorial integrity and sovereignty of another state. There is no such thing as violating the territorial integrity and the sovereignty of another state. That is not allowed. In the name of trade, if you try to violate the territorial integrity and the sovereignty of another state, it is a violation under international law. That is the clear expression that is being pointed out. Now the last one, Article 2, Paragraph 6 of the Charter of the United Nations. I don't want to speak another thing. Article 2, Paragraph 6 of the Charter of the United Nations makes very clear, even non-members of the United Nations are supposed to act in conformity with the Charter. Whether you are a member of the United Nations or not, it makes no difference. You are supposed to act in accordance with the principles of international law. No state can say, I am not a member. Since I am not a member, I am not bound by the rules of law. If such a statement is made, you think of what happened to Saddam Hussein. You think of what has happened to King Kaiser William. You think of what has happened to Adolf Hitler. Or you think of what has happened to the great, ruler of Yugoslavia, President Milosevic. Such a thing is going to come. If you do it in the name of trade, naturally, international community is not going to pardon you. Even non-members of the United Nations are supposed to act in conformity with the Charter. It is a rule of international law. It should be respected, it is respected, and it ought to be respected by a particular state. Now, in international trade, these are the guiding lines. Most of the treaties, when they are drafted in accordance with the parameters, which most of us are not able to understand. Now, in addition to it, there are two other guidelines which are being spoken, and which are this. Now, in the year 1974, the international community, especially the General Assembly of the United Nations, adopted a declaration. And this declaration in human history is popularly called as NIEO, New International Economic Order. Now in the New International Economic Order, it clearly lays down sovereignty over the natural resources should be exploited by a particular state. Now when they stated this, they quoted an earlier resolution of the General Assembly of 1960. In 1960, the General Assembly of the United Nations unanimously adopted a declaration. And this declaration happened to be a declaration relating to sovereignty over the natural resources. In this declaration, the resolution clearly stated, as far as the exploitation and exploration of the natural resources of a particular country is concerned, that country is sovereign. Under no circumstances an outside state can interfere with this. And if it does, it is an interference and intervention in the internal affairs of another state. Now you think of this. See, there is a reason for the adoption of this resolution in 1960. And it was repeated in 1974. The reason is obvious. Most of the states became independent after 1945. I don't know whether you know this or not. When the United Nations came to be established, there were only 50 states. By 1960, remember, the strength had gone up to 100. These 50 new states which are admitted as members of the international community, were colonies earlier. And these colonies, when they became members of the international community, their pre-colonial masters started interfering with the exploration and exploitation of resources. They said, we have the technical know-how, we have the manpower, you exploit, your resources are exploited. I don't know, students, remember when you read of IPR, you should know the trade union law as well. When we speak about the trade union law as well as part of environmental law, we speak of two important things. The first one is, remember, the British people did not develop environmental law initially in this country. Most of the wood, precious wood, I am telling you, your teak or rosewood, whatever it is, used to go from this country, from Kerala, from Karnataka, from Gujarat, used to go to the state of England for purpose of building ships. And they used to go to Liverpool in London because they had a backyard, a ship backyard. And there they used to big ships. And these ships were used for purpose of waging war with other countries by the colonial master. This is one. The second one is the entire forest, Ratnagiri forests were eliminated once by the British. And the Kerala forests and the Karnataka forests were cut off completely for purpose of building sleepers in the railways by the British, and it was taken by them there. Oh, that is why sovereignty over the natural resources must be exploited by the concerned state. They knew, they had an apprehension. States who became independent had an apprehension saying that now we have become independent. But will these super masters will survive, allow us to survive as independent nations in the international community? They will not. That is where they mooted the idea and the resolution was passed. When the resolution was passed in 1974, members of the international community of the developing countries were not happy with this. And hence they adopted a charter of economic rights and duties of states in the very same year. In the year 1974, the Charter of Economic Rights and Duties were adopted along with the new International Economic Order. In the Charter of Economic Rights and Duties of States, it is very clear, in crystal clear terms it is stated, exploration and exploitation of the natural resources must be done by a particular state. You may ask me, what is its relevance to IPR? Think of the biopiracy that is taking place in this country. The entire biopiracy, what we call your Ayurvedic medicines, your Unani medicines. Now most of it has its origin in this country. And it is being taken and it is being protected there, and these people are making money. And we don't get it. And it is contrary to these resolutions and the conventions. How many of us are speaking about it? Nobody is speaking about it. We speak here in this platform. And it is you, younger generation, people of the younger generation should champion these causes. That is why wherever I go, I just make a reference to this. See, first and foremost, most of the laws in this country are framed by those great men, Britishers. And it is a carbon copy of the laws. I can just tell you, as an advisor, when I served in the state of Bahrain, now most of the advisors in the state of Bahrain happen to be Egyptian advisors, because Arabic was the mother language. It had to be drafted first in Arabic. I was taking care of the international division, legal division. Now the point is, remember, Arabic simply means they will bring the Egyptian law. And it is already drafted in Arabic in Egypt, in Arabic for the Egyptian country. And they will bring and just name the Egyptian, delete the name of the Egyptian Republic and make it the state of Bahrain and put it. Without even exercising, thinking of whether the state of Bahrain with such small population is required such a legislation. No, here it is verbatim. The British have enacted the law and we are implementing it without any changes. Have we ever thought of it, the concern for the developing countries in the legislations? Do you have a clause protecting our interest, our integrity, our sovereignty in any legislation? Our representatives go and participate, and afterwards, at the end of the day, you must have seen Murasoli Maran walking out of the WTO meeting, ministerial meeting. And everyone was showing. They were showing his kurta and pancha and bushcoat. And what he spoke was shown to you. Did they make a mention? What he had? How did he express? Nobody. Have you heard of it? Your NDTV speaks of independence. Did they speak about it, show it to the public? They did not. This person championed, he said, we have nothing to do with your WTO. It is a clear case of exploitation. How many of us have known? Because I was there at that time. It came in the Arabic newspaper, translated in what we call as the Khalij Times and Gulf News. But then our newspapers did not speak about it. That is the kind of freedom which we enjoy. We don't come to know always news fabricated. See, in such a situation when we live, what is important is laws which are enacted in this country must serve the interests of this country. That is not happening. That is what I just wanted to say. And it is no way different in the area of IPR. Somebody spoke about the patent rights and the patent law. See, Section 5 and amendment that is being introduced to Section 5, if I am right. How many writers have pointed out it is unclear? And how many teachers teach this in the class that it is unclear? And how many of us know that it is unclear? And somebody spoke about Diamond versus Chakravarti. And when we speak about Diamond versus Chakravarti, if you read Section 5 and 6, there is no difference between a discovery and an invention. In some countries, for example, in Latin American countries, even discovery is being patented. What is left now? Put a question to yourself. And in some other countries, no, naturally, invention has to be protected. I see, if you think of this, I shall just point out 2 or 3 important errors which you find, or the mistakes that we find, glaring errors which we find, which are to be corrected in the TRIPS. I don't want to prolong much. The first mistake that we find in the TRIPS agreement is the elements that are being contained to grant a patent. First it says it should be an invention. Second it says it should be new, there should be novelty. And the third one it says it should be capable of industrial application. See, these are the 3 things. One is it should be an invention. What is an invention? Whether it is defined? Look to the Patent Act, a Patent Amendment Act of 2005. You have only 1.5 sentence. I just read it in the morning. I was reading it here only. And I kept it. What is the fun in reading it? It is a waste of time. It is not clear. I am telling you, the TRIPS agreement doesn't specify what it is. Unless, see, for example, it gives a small explanatory note. Explanatory note is not enough to come to a conclusion, because discoveries are of different types. Patents are of different type. This is the mistake. Invention is not properly defined. Novelty is not properly defined. What is an inventive step is not defined properly. It is here the developed countries are taking refuge and exploiting you further. It is here, remember, in the state of United States, soon after the decision of Diamond versus Chakravarti, patenting of life forms were permitted. Now, once in 2 years, ministerial committee of the WTO is meeting. They spend a lot of money, a lot of advertisement is given, a lot of NGOs go there, a lot of newspaper people also follow them, and some agitations are being carried. Whether these agitations have helped in correcting this mistake? I am putting a question to you. In the last time, see, at least in 6 places, the ministerial meetings have taken place. And in these 6 meetings, only farmers putting agenda. Pharmaceutical companies are putting agenda. And pharmaceutical companies, the owners are saying, we are not bishops, we are not that generous, we are here for business. Thus far, no further. Anything have taken place there afterwards? Why this is not rectified? That is the fundamental question which you should find, and you should write articles on this. What kind of changes are required? That is research. Research simply means it is action. Translating knowledge into action is research. And if we don't inculcate these kind of things in your minds, it is our life is gone. It is a sheer waste. As teachers, it is our responsibility in inculcating originality in your mind. This is not done. Now the second important thing is we speak of patents. Now patents, remember, that is the reward or the award that is being given to a researcher for having spent precious time in the laboratory or in a lonely place. And it is an honor that is being conferred on him by the society. It is a privilege that is being conferred on him by the society for a temporary period. Now if this is a privilege that is being conferred on the discoverer, how do you equate with this natural right? Can a patentee, patent padadama, whether a patentee, remember, consider this honor which is being conferred by the legal system as a natural right that is being given to him? This exactly is the problem. See, you are living, especially in a country like this, wherein you have it is a multi-dimensional society, multipolar society. You have so many religions. If there are 12 religions in the world, we have all the 12 religions in this country. If you speak of 6,000 castes, we have all of them here. If you speak about the poorest of the poor, we have. The other day I made a statement from this forum. Remember, there are 32 crores of these people whose income is less than $1 a day. Then for a patent holder, if you are the patent holder, if you consider it as your natural right, remember, your discovery should be useful to the society. Your discovery should serve the society. You should uplift the standard of living of the people in the society. If that is not going to be done, remember, we require such researchers. We don't want such researchers in this country. Whatever you do, you should serve the interests of society. It should serve the people of the society. If you do any research, you should help the people, the masses, provided whether it is a social science research or some other research. Now some people, morning you were saying most of the research is duplicated here. Professor Ravindra himself made the statement. Now I can go and add further. When I was in JNU, I was sitting with the librarian once. The librarian once told me, Mr. Subramaniam, 97% of the research that is taking place in JNU is duplicated research. If it can be JNU, think of our conventional universities, it is 100. Get the point. There cannot be original research at all. That you forget. I am not speaking on research. See, the point at issue is any invention that is being done in the society should be useful to the society. And that is where it cannot acquire the characteristics of a natural right. You can never ever, it is possible to equate a patent with a natural right. Then the third one is, remember, always when you do certain things, public welfare criteria should be taken into consideration. What you have done, what you have, remember, discovered is going to serve the public. No, if this is not going to be taken into consideration, for what purpose you are doing research? I am just putting a question. See, he has registered a patent in the United States. Agreed. You want a tender coconut, take it, we will give. But then it should serve the people, serve the masses. Now, for example, you take it this way. In 2001 and 2000, the subcommittee of the United Nations Commission on Human Rights discussed threadbare about the implications of the TRIPS agreement. Having discussed the implications of the TRIPS agreement, they went to the extent of pointing out the TRIPS agreement violates basic human rights. Nor it caters to the need to respect basic human rights. Now you may put a question, what these basic rights are. First one is right to health. ಮನುಷ್ಯನಾಗಿ ಸಾಯಬೇಕು, ಡಿಸೀಸ್ ಇದ್ರೆ ಏನು ಪ್ರಯೋಜನ ಇದೆ? You will be like it is an animal existence. So first one is right to health. The second one is right to food. Then right to livelihood. Right to self-development. Right to self-determination. And right to live in an unpolluted environment. Now, when we look into the TRIPS agreement, all the 4 rights which I have just mentioned